Hey guys, welcome back. Okay, so we're in chapter 8, and if you notice, we have basically one more week before the midterm. So if you have questions or comments or concerns, please get a hold of me and I'll be happy to talk to you about that. Alright, so one of the things that's important to know is how a trial is run. And civil and criminal are similar in many ways. Let's kind of talk about the civil aspect for a second. So let's say the parties, plaintiff and defendant, don't go ahead and settle prior to trial. The trial is set. They will probably try with the judge one more time to have a settlement conference, and usually that never works, hardly ever in my personal experience, and the parties still go forward. And so then there'll be what's known as pre-trial motions or motions in limine to either let evidence in or not let evidence in. And one of the things that also happens before trial is a status conference or a calendar call. It's called a status conference here in San Diego, pre-trial conference. And that's just to let the judge know kind of what is expected at trial, how many days, how many witnesses, that sort of thing. And then once all these pre-trial things have been taken care of, then a jury or potential jurors are invited into the courtroom and voir dire is conducted, which is questions of the jurors to see whether or not plaintiff and defense attorney think that this person would be a good juror. Then usually in civil, at least, both sides make an opening statement at the beginning. Sometimes in criminal this is a little bit different. One side will reserve to do their opening statement later. After opening statements or statement, the presentation of the case is done. This is basically calling witnesses, asking them direct questions, and then the other side cross-examining them. At the end, there'll be closing arguments for both sides typically. The jurors are given instructions by the judge on what the law is, so that they're not supposed to be going back and applying what they think the law is. They're supposed to actually use the instructions and apply that. The jurors go back into a private room and deliberate, and then once they've figured out their decision, the verdict is read in open court. Okay, so a status conference doesn't just happen before trial. It happens all throughout the case, at least especially in civil, so non-criminal cases. And most attorneys have several of these scheduled for the same date and time. So they run around going to all the different court rooms that they have an appointment in, and they drop off their business cards or tell the court clerk where they're going to be, and they try to get it so they go to one and get in line first, and then they can come back to like the second or third courtroom and show up a little bit later, because many cases are set at the same date and time and not everybody can be heard at once. So usually the attorneys are waiting around for a few hours to get heard, or they're going from courtroom to courtroom to hit all their different conferences. Okay, so this is a very good book, but one thing I think that's a little bit confusing about it is it goes back and forth between talking about civil and criminal. So in civil court, the parties settle. In criminal court, it's typically the defendant's found not guilty, or he's found guilty, or he's decided to make a deal and plea bargain. So talking about settlements in civil court, like 95% or more of all cases settle prior to going to court trial in civil court. And this is because you just never know what a jury will do. And so a lot of times the attorneys make the decision to settle out of court because it's more certain what will happen, I guess is what you could say. All right, so if they do a formal settlement after trial has started, it's known as a Section 998 offer, and it's a special form that has to be filled out for a settlement that occurs after trial starts. So almost all lawyers, because it's our job, not just because we're evil people, are concerned with money, and there is a series or publication that is called What's It Worth, and that can be looked at and to decide whether or not to take a case, to see how much those types of cases are paying out, particularly in civil cases. So for example, after the McDonald's hot coffee case, was asked by a law firm to look at cases where a waitress spilled hot coffee on a man and find out how much those cases paid, so the law firm could decide whether or not it was worth their time and effort to take that case on contingency if they would make a high enough amount out of that to go ahead and take the case. Okay, so this is an interesting case because it's against Trump Plaza Hotel and Casino, and this particular plaintiff didn't do so great because originally they were offered $6,000, but in the end, after they went to trial, they only got $750. So they would have done better settling. Okay, so I'll let you read this slide on your own, but I just want to point out we're back to talking about criminal cases again. So plea bargaining is in a criminal case and not in a civil case. Okay, so almost every alleged criminal will go ahead and do their trial. And the reason for this is, even if they think they won't win their trial, it's a great way to get out of jail, have different changes seen, and there is always that chance that they could be found not guilty. So more criminal cases go to trial than civil, because if you recall a couple slides ago I said in civil less than 5% of all cases go to trial, but in criminal there's a huge, way more bigger percent that do go to trial. So a lot of times in criminal, the defendant doesn't have money for an attorney, doesn't have money for court fees, and so a criminal defendant is entitled to a public defender typically. Sometimes it's an alternate public defender, sometimes it's an alternate public defender if they've been found guilty of prior crimes. In civil court, it is expensive. The person can represent themselves. They're not typically entitled to have a court-appointed and court-paid-for attorney. And even if they don't have an attorney, there's lots of fees Some of these can be waived through a fee waiver. There's some fees that the plaintiff would still have to pay. So this is one of the reasons that civil trials tend to settle more than criminal trials do. I highly recommend that if you can, and you're asked to go ahead and serve on jury, because it just gives you such a different perspective of the entire legal field, and it really educates you on the trial process. So make sure you know for exams that it's a jury trial if the jurors hear the trial and decide it, and it's a bench trial if a judge decides the case. And typically in civil, somebody is usually entitled to a jury, but they might decide that they want a judge to decide the case instead, so to have a bench trial. Okay, so for this slide, make sure you read it, because I do believe I have a question on the midterm from this slide. So hint, hint. You want to pay attention to the difference between preemptory challenges for civil versus this is actually talking about criminal. So if you look in criminal cases, trying to circle that, then you get, so this is confusing. So in criminal cases, you get 20 for the defendant and 20 to the plaintiff, which is the people. Okay. If it's a death sentence or a life in prison case, but if it's not death or life in prison, then it's only 10 each side. Okay, so that's very different than the last slide that talked about civil. So typically, depending on whether or not a preemptory is for challenge or for cause, the side trying to get rid of a juror will or will not have to go ahead and give information as to why they want to get rid of that juror. So for cause, you have to give the reason, and otherwise you typically don't. But I have actually been in jury selection where the opposing side was actively trying to get rid of all people based on their ethnicity, and that is not allowed. Okay, so challenges for cause are basically made because of severe bias expressed by the juror, you know, them stating that they could absolutely never find somebody guilty of the death penalty for religious reasons, or you know, stating verbally that they will never ever do what the judge tells them to do because they don't agree with that law. Okay, so typically who goes ahead and makes the opening statement first is whoever has the burden of proof. So if you remember, in civil, the burden of proof is on the plaintiff, and it is preponderance of the evidence. And in criminal, the burden of proof is on the people or the prosecution, and their burden of proof is beyond a reasonable doubt. Okay, so we skipped several slides for your audio. And in the last slide, we were talking about motions in limine, so hopefully you reviewed your regular PowerPoint. And a motion in limine, to remind you, is a motion to exclude evidence typically. And one of the big ones that we do for motions in limine is whether or not the plaintiff sued other defendants in a case, especially in a civil case. So if a plaintiff had 3 defendants it was going after, and then suddenly 2 of them are out because they settled, then a lot of times we don't bring those other 2 defendants into the trial against the 3rd one, because that just confuses the jurors and they don't think it's fair, and they don't always understand that plaintiff settled with the other 2 people. One of the biggest misconceptions is that the defendant in a criminal case needs to speak up at trial. The defendant has absolutely no requirement on him or her to speak up at trial. Remember, the burden of proof is beyond a reasonable doubt. So it's completely upon the prosecution or the government to go ahead and prove the defendant is guilty. So the defendant doesn't need to get up and try to convince anybody of his innocence. Okay, again, we skipped several different slides, and we were just talking about jury instructions, so I hope you're reviewing your regular PowerPoints and also then doing your audio, so you get the most bang for your buck, so to speak. Okay, I wanted to give you an example of a jury instruction because the jurors aren't supposed to go back and just give their personal opinions on whether or not somebody is, liable or guilty. They're supposed to apply the law. And so they're actually given the laws, and this is what they're supposed to apply. So for example, this one says, a parent abandons a child by actually deserting them with the intent to cut off the relationship. So that means if the case is about that, then the jurors can't go back and say, okay, well, the parent abandoned the child, unless they can find that there was intent to abandon the child.